The information shared in this podcast is intended for entertainment purposes only. It should not be considered as professional legal advice or a substitute for seeking professional legal advice. The issues discussed today have not gone to trial, and no trier of fact has made findings as it relates to the claims of the respective parties. Nothing herein is to be construed or used in lieu of any future findings made by the appropriate trier of legal disputes. Divorce, custody battles, domestic violence. These cases unfold every day in family courts. But the stories don't end in the courtroom. The courtroom is just the beginning. This is Love, Lust, Law, and I'm your host, Michele Locke. I've spent 23 years practicing as a divorce attorney and presided over more than 5,000 cases as an associate court judge in Texas over a dedicated family violence court. I'm also the child of divorce, and after a 22-year marriage, I've been through one of my own. When I say I've lived every side of family law, I mean it. Now I'm bringing that experience to the mic so we can unpack the legal battles fueled by love, lust, power, money, betrayal, and survival. Today I'm joined by Jake Deptula, a seasoned victim advocate and podcaster who just so happens to be my executive producer and friend. Last episode, we broke down the origins of the legal battles between Blake Lively and Justin Baldoni, a fight that started quietly behind the scenes of It Ends With Us. We talked about how Blake was initially excited to sign on to the project until Justin, who was her co-star, director, and producer, allegedly began making inappropriate changes to the script. From there, things escalated. Blake said she was subjected to repeated harassment, unwanted physical contact, and retaliatory behavior on set. She pushed for protections and eventually got them. But just before the movie's release, Justin and his team allegedly launched a covert smear campaign, working with a crisis PR firm to bury Blake's reputation and protect his own. By the time the movie came out, Blake was being dragged online while Justin was being honored for his advocacy work. That changed on December 20th, 2024, when Blake filed a formal complaint with the state of California. The very next day, the New York Times released a damning expose. Celebrities and studios rushed to support Blake, and Justin's reputation took a major hit. In today's episode, we're walking through everything that happened next. Blake's official lawsuit, Justin's legal response, and where the case stands now. We have a lot to get into, so let's get started. On December 31st, just 11 days after filing her formal complaint, Blake escalated the matter to federal court, filing a lawsuit in New York that closely mirrored the claims she had already raised in California. She wasn't asking for a specific dollar amount. Instead, she said she was seeking an amount according to proof and an amount to be proved at trial. Attorneys for Blake said in a statement, as alleged in Blake's federal complaint, Justin's production company, Wayfair, and its associates have violated federal and California state law by retaliating against her for reporting sexual harassment and workplace safety concerns. Now, the defendants will answer for their conduct in federal court. It is interesting, their pleadings and their tactics, for a couple of reasons. They are coming at Baldoni and Wayfair in multiple avenues because seeking relief in federal court means there's an allegation of a violation of federal law, and federal court is usually the last place you want to end up. I practiced in federal court in the Western District of Texas and a little bit in the Fifth Circuit Court of Appeals early on in my career, and federal courts are a different system. Even me as a 23 licensed year attorney who's a litigator and does jury trials, I don't like going to federal court. I don't. It is uncomfortable. It is strict pleading requirements. It is just a whole different ballgame. So the fact that they filed in state court and then one in federal court, basically across the country, tells me that they're coming after him on all possible avenues to apply more pressure to Wayfair Productions and or Baldoni. It was basically, we're serious, we're not going away, and now you have to deal with us in 2 states.
Justin denied all of the allegations, and on that same day, December 31st, he filed a lawsuit of his own. But his target wasn't Blake. It was the New York Times. Justin was seeking $250 million in damages for multiple complaints, including libel and false slight invasion of privacy. He also listed 9 co-plaintiffs, including Wayfair Studios, his publicist Jennifer Abel, and crisis PR expert Melissa Nathan. The lawsuit was stemming from the We Can Bury Anyone inside a Hollywood smear machine expose they released one day after Blake's complaint was filed in California. Justin's lawsuit claimed the Times had relied on cherry-picked and altered communications, details, stripped of necessary context and deliberately spliced to mislead. His attorney released a statement blasting the paper, saying the Times cowered to the wants and whims of two powerful, untouchable Hollywood elites, aka Blake and her husband Ryan Reynolds, by using doctored and manipulated texts and intentionally omitting texts which dispute their chosen PR narrative. Michele, what are your thoughts on this? Was this lawsuit expected? Why would he go after the New York Times first?
So what is interesting about litigation when lawsuits get filed? Behind the scenes, before the lawsuits get filed, there's typically exchanges between attorney camps on demands, threats. Here's what we're going to claim. There's probably a cease and desist at some point that went to someone's team on either side. What I would suspect is that Justin and his team really thought that Blake and her team were feeding the New York Times information. I think that's basically what they thought. And so why he would go after the New York Times first may simply have to do with timing, because he may not have been served in the federal lawsuit yet with regards to the New York federal lawsuit. Also, he was probably preparing his own counterpetition in the New York lawsuit. And that takes a little bit longer to draft. And if anyone looks at the pleadings in these cases, in this particular case, the pleadings are not short pleadings. They're not 2-page documents. It may have been an easier and quicker avenue for them to get them back in the media saying, nope, New York Times, you all are misleading and misrepresenting what's actually going on. While at the same time, they're still working on their counterpetition for federal court. So it probably was somewhat strategic, but also that was a probably quicker one to get out for his team than the counterpetition in the federal lawsuit.
Do you feel that him dragging the New York Times through the mud and possibly getting some form of retraction or mea culpa would have added more credibility to his suit or his fight against Blake?
He could have, but if we remember what we talked about on episode 1 and some of the content of some of those text messages that have come out, I think it was probably strategic with his PR people and his legal advisors that said, nope, we got to defend us on all fronts on the smear campaign. And so the best way to do it is add everyone as a co-plaintiff and say, no, this isn't true. It's being misrepresented or cut and spliced, to kind of counteract what Blake's lawsuit in the federal court is saying. It's because then you can go in front of a judge. Judge, we filed suit against the New York Times because this is not true. Judge, we've got this litigation. Here's our counterpetition. And so it, to some extent, may be used by his team to up their credibility.
Well, to your point, though, is that obviously the New York Times, LA Times, any sort of established periodical, they're not in the business of publishing full lawsuits, right?
Correct.
They're using bits and pieces of evidence. And that is traditionally what media does, right? They'll pick a narrative, they'll pick a POV, and they'll use elements to back that up.
Of course. It's persuasive writing at its finest.
100%. So, but in this standpoint, anybody technically could sue a periodical for what they consider an article that puts them in a bad light or a negative light. Is that correct? Or does it have to be something established to say this is inaccurate? Because somebody can say, well, the New York Times could say, well, we don't like Justin Baldoni, so we're going to write a smear piece on him. But if they've got the evidence to back that up and they pull it directly from, let's say, a bigger sampling of evidence without misleading, but showing just the bad evidence or just the negative things, isn't that within their right to do so?
So that's going to go back to basic libel and slander laws, and those vary state to state. And then you add in that they're a public figure, which usually changes what you have to prove libel and slander, depending on the state you're in. So it gets a whole lot more complicated than just a simple analysis of, well, they probably can. I would strongly suspect that the New York Times has legal advisors that have advised them many, many times on what they can and can't do. I would also suspect that this probably got run through their legal department first as well to see if they were within their rights. I just suspect there was a lot going on behind the scenes. And here's the other issue. When you're writing articles and you are trying to tell a narrative, you can't put the whole petition in a newspaper. You simply can't. And so how do you do journalism by putting everything in? There's not enough time.
If someone has a negative piece of evidence against you and they publish it and they craft a narrative around it without alluding to anything beyond what is in that evidence, aren't they within that right, especially obviously if you're a public figure?
I think so. Listen, if you've got a text message like they have that we talked about in episode 1, I think it's fair game. You wrote it, it's in writing. Now, the problem becomes is if they, I think, omit like the second sentence of one of the messages that may have changed the entire context of that first one. I know when we go to family law courts, one of the questions that attorneys almost always ask when you've got text messages is, well, isn't this what you said? And it's some inflammatory, terrible text message. And usually, if you look one or two down, not always, but sometimes there's a response that completely changes what that initial inflammatory comment was. So here's what I tell clients when that happens is that if you know they're putting out a text message and that text message is a portion of it, but not all of it, your response is, well, yeah, that's a portion of what I said, because the rest of the portion may change it. And then if they don't get into it, then it's my job as their attorney to bring the rest of that evidence in. A lot of times we refer to that as something called the rule of optional completeness, that they've only put in a portion of the message and judge, we're going to complete the entirety of that record so that it's clear what actually happened.
As the new year began, the legal battle between Blake and Justin continued playing out in the press, with both sides issuing public statements through their attorneys. On January 7th, Blake's side released a statement saying, "This is not a feud arising from creative differences or a he said, she said situation. We ask everyone to remember that sexual harassment and retaliation are illegal in every workplace and in every industry." Justin's attorney fired back. It is painfully ironic that Blake is accusing Justin of weaponizing the media when her own team orchestrated this vicious attack by sending the New York Times grossly edited documents prior to even filing the complaint. He went on, "We are releasing all the evidence, which will show a pattern of bullying and threats to take over the movie. We have all the receipts and more."
The next day, Justin's attorney appeared on the Megyn Kelly show to discuss the case. And I do want to note that the two already knew each other as he had previously represented Megyn. Conflict of interest? I don't know about that. Just as a side note, conflict of interest rules are very specific on what you can and cannot do, what you can represent, what creates a conflict for down the road. And I really don't think it's necessarily conflict as just hey, he had a connection to get onto the show to talk about it. I mean, he used his connection to get him somewhere, or at least get him on the news. Legal conflict, I don't think it's really an issue, but just a connection that got him some press coverage. During the interview, he played a voice message that Justin had allegedly recorded after the It Ends With Us premiere on August 6th, the same premiere that fueled speculation when Justin wasn't seen with the rest of the cast. In the message, Justin was telling his team about how he'd been forced to stay in the basement with his family during what should have been a career-defining night. He said, "I literally was sent to the basement with all my friends and family for over an hour because I wasn't allowed to be seen. Blake didn't want me anywhere near her or the rest of the cast." He said, "We started laughing because of the ridiculousness of this whole thing. I was in the basement with the people that loved me the most, and we were all joyful and laughing because none of that shit matters. None of it." Justin ended the message by saying, "That's not why we're in the business. We're in it because we're artists and we believe in what we do. The truth will prevail and light and love will win."
Now, here's what's interesting. Neither Megyn Kelly nor Justin's attorney explained how the voice note was obtained. And according to Deadline, the message could not be independently verified or dated. But that wasn't the only thing revealed during the interview. Justin's attorney also said he planned to launch a public website that would include every single text message, every single document. Michele, can you talk about the legality of doing something like this?
Oh, if you put it in writing, that is why I tell clients, everything can be Exhibit A. And if you send it out somewhere into the universe, email, for example, text message, for example, voicemail message, for example, it is subject to being displayed. Unless there's some gag order from the court that says you can't do this, I think they have a right to do it. I don't like it. My personal opinion, not legal opinion, my personal opinion is that it's in bad taste. But this case also is being tried out in the public forum because everyone's image was really being put on trial in the public arena. It really was. So they did what they had to do, which was go public. Now, what I find is interesting is they say that they're going to publish every single text message and every single document. Whether you know that's true or not, I don't know. I would doubt that they would turn over or produce for the public everything. I would suspect that is not an entirely accurate statement.
Once it goes into the court case, how much of that evidence can be released, or how much does the public have access to once it's filed?
Well, courtrooms are public as a matter of law. And so anything that's introduced into evidence, absent some kind of confidentiality order, absent some sealing of the records, absent some additional action taken by the parties, agreed to by the parties, or ordered by the court, anything that gets introduced in a courtroom is public domain. It is you can request a transfer of the proceeding. It's accessible. And so oftentimes, at least in the family law side, do you really want all of this in the public record? Probably not.
To that point, though, Justin's attorney would potentially not be doing anything that the public wouldn't be able to get access to through the court case anyway, right? I mean, I'm assuming all this stuff would be there.
Not necessarily true, because not everything is filed with the courts. Not everything is presented in court on the record. So there is written discovery that goes back and forth between the parties that's produced in litigation. That's a different discussion because that's not really a public forum. My belief would be that anything that Justin already had prior to litigation, so the text messages, he can produce all of that he wants because he already had it. The other issue becomes when you talk about damages in a case, punitive damages, exemplary damages, lots and lots of millions of dollars in damages, there becomes some financial disclosure element in the case. And so you wouldn't want to be posting someone's HIPAA information that you received in discovery. You wouldn't want to be producing someone's financial documents you received in discovery. To say that because they sent it over in discovery, it's public domain would not be accurate. But if it's produced in court, in open court, on the record, and there's nothing that prohibits the disclosure of it or dissemination of it, it's fair game.
Do you feel that this is a strategic move in order to win a court case or to defame or cast a negative light and threaten Blake's team, thinking that there's something that the public would not respond favorably to in some of these messages?
I really think it's option B, because under the first option, which is it's a legal strategy, not everything that you have in your care, custody, and control, right? Not everything that Justin had prior to litigation may not have been admissible in court, right? Some of for example, the recordings, you have to properly authenticate evidence to come in. They may not have been able to properly authenticate that. So what are they doing? They're putting out in the public sphere so that there is some listening of it, some judgment on it, which potentially, if it's going to a jury trial, could affect potential jurors because they may have already heard it. Now, that again should be covered in voir dire when you're picking a jury, but that's another discussion of itself. But just because he has what he believes is evidence doesn't mean that evidence comes into court. About a week later, on January 16th, Justin filed a civil lawsuit against Blake, Ryan Reynolds, and the couple's publicist, Leslie Sloan. The suit accused them of many things, including extortion, defamation, and intentional interference with contractual relations. Justin, his production company Wayfarer, his publicist Jennifer Abel, crisis PR expert Melissa Nathan, and Wayfarer CEO Jamie Heath were all listed as plaintiffs. Together, they were seeking $400 million in damages. According to the lawsuit, Blake had used her immense power as one of the world's best-known celebrities to rob Justin and Wayfarer of creative control over It Ends With Us. Justin claimed Blake went beyond the scope of her contractual entitlements by leveraging her and Ryan's star power to steer the film in a different direction. That included having Ryan rewrite a scene and make unauthorized changes to the script in secret, even though he had no formal role on the project. The lawsuit also alleged that both Ryan and Blake's friend, Taylor Swift, made it clear to Justin that he needed to follow Blake's creative direction.
To support their claims of extortion and defamation, Justin and the other plaintiffs argued that Blake set out to destroy their livelihoods and businesses when they didn't give in to her demands during production. They said that once they refused, Blake retaliated by accusing them of foul and reprehensible sexual misconduct. The filing stated Wayfair was blindsided when Blake refused to return to production after the industry strikes unless they agreed to her non-negotiable protections for return to production, a document the company claimed was signed under duress.
That's really interesting side note, considering if we go back to episode 1, when they issued a letter saying that basically all the demands were reasonable. And so, sure, we have no problem implementing this. So that is interesting, taking into consideration what was issued in that statement.
At that time, it was Justin, it was Wayfair, it was Sony all involved and all sort of agreeing upon what those terms would be to make the set a safe place.
I find to say they signed it under duress, considering what we discussed in the previous episode, is really interesting.
Duress, if you want to quantify that word, if Blake is the star of the movie and decides to trash the movie, pretty much most of the investment will be gone. So this is a very tricky thing when it comes to movies, when it comes to promotion, is that until the movie comes out and is on the PR campaign, it can be a very tenacious position if there is any sort of static between the lead actor, the production team, the studio. A lot of these battles have been played out before and have sunk other movies. When people speak out, whether it's an artist speaking out politically or about something that is sort of capturing the nation or the world's attention and they take a stand on it, then that can impact that. But outside of the political stance, when there's any sort of smoke on a movie set, there's usually fire. There have been major movies that have gotten out of control, budget overruns, and then you've had, let's say, very demanding lead actors who make conditions so difficult for everyone around them, they end up trashing the movie before it even hits theaters.
With the whole there's smoke, there's fire, that applies in regular life too. I mean, really, think about it. But then I go back to switch back to movies. Then the converse is true, because I'll never forget A Star is Born with Bradley Cooper and Lady Gaga. Their press tour and what they managed to publicly cause fluster over, that Bradley and Lady Gaga, there was something going on with them. And it was never stated, I think, that they were together. But man, every appearance those two did leading up to the Oscars was absolutely intentionally driven to drive the conversation and I think help promote their chances for some kind of Oscar, or forgive me that I'm not so Hollywood savvy in all the awards that you probably are, but it was definitely during award season that it appeared that they had strong feelings for each other. Like that one performance they did, was that at the Oscars?
Oh, Shallow, I think it was.
It was Shallow.
You know, what's interesting about what you say there is that there was something to that PR campaign that was very organic, and you could tell their chemistry for each other on screen and off screen.
It's really interesting to see the dichotomy between like what happened with Blake and Justin versus what Lady Gaga and Bradley Cooper were able to do.
Even to that note, the fact that any of this stuff didn't necessarily harm the box office of It Ends With Us, because let's be fair,
it didn't.
Dramas don't always do extremely well, at least not in this climate anymore, theatrically. It's mostly high octane, high concept action movies.
Marvel.
Yeah, anything possibly superhero related, which is now hit or miss. Like some of them do really well and other ones completely don't. They're more event movies. To me, It Ends With Us, you wouldn't put that as an event movie. However, these are some of those, sometimes like those sleeper hits, which come out of nowhere. And I think Colleen Hoover's fan base is so strong that ultimately that's probably what drove this above and beyond any controversy.
Well, it's kind of like when you have the Swifties. Don't get the Swifties mad at you, ever.
And let's be fair, Taylor Swift's power when it comes to this, the music, everything else like that didn't hurt.
Nope, did not hurt at all. The lawsuit claimed Blake later used that agreement to seize control of the film, eventually securing her own cut, receiving a producer credit, and removing Justin from all marketing and promotional efforts, including appearances with the cast and Colleen Hoover. Despite this, Justin continued promoting the film as he had always intended, which was to bring awareness to domestic violence. Justin claimed that when Blake didn't do the same, she was labeled as tone deaf. She then doubled down on her false claims against Justin. She was trying to make him the real-life villain in her story.
The complaint also accused Blake's publicist, Leslie Sloan, of propagating malicious stories portraying Justin as a sexual predator, a term they claim Ryan Reynolds used himself when calling Justin's agent and telling him to drop Justin. Modern society justly reviles sexual harassers and abusers, the suit said. And Blake knew full well that making those allegations would be a career death sentence for plaintiffs. She did not expect, however, the plaintiffs would be able to meet those allegations with concrete documentary evidence, disproving her claims and demonstrating that they, not Blake, were the targets of a calculated and vitriolic smear campaign. Michelle, I'd love to hear your thoughts on this so far.
Man, for me, when I started reading the complaints and the pleadings, I'm like, y'all, this is a soap opera. This is not family law. It's civil litigation, but boy, does it have the hallmarks of family law. It's the salacious. It's the text messages. It's the late voicemail messages left to Blake at 2:00 in the morning. I mean, this is all the hallmarks of a broken-hearted relationship. I mean, it really does. There's someone that's bitter. There's someone that's angry. There's both sides think they've been wronged. I mean, welcome to divorce. It is salacious. As the lawsuit continued, Justin countered Blake's allegations with his own evidence. Variety reported that the filing reads like an extended counter-narrative rather than breaking down the alleged defamation point by point. Caitlin Kovacs, an attorney who specializes in defamation, further explained that Justin mostly argues Blake's twisted his words or took them out of context, not that she fabricated them entirely. And that distinction matters, especially in court. And that could not be more accurate. It's interesting to note that the judge will eventually rule in this that Justin never alleged Blake made any statements outside of what was in her complaint, which are privileged. And I don't think necessarily the term is privileged. I think it's protected. Like what you're saying in litigation and you put in your complaint when you outlie your facts, like, and in federal court, you have to 1, 2, 3, 4, 5, you number every paragraph. When you make those allegations, you can't then use that as the form for a defamation claim. The judge would later rule that Justin failed to prove that Blake and her side had no reason to doubt the truth of what they said. And that's the other element. Because remember, truth is always a defense. And so if you know the truth and you are doing something in contravention and making statements contrary to what you know the truth to be, you get in trouble.
Let's get into an example of Justin arguing that Blake twisted his words or took them out of context. This example centers on Blake's allegation that Justin had inappropriately called her sexy. Justin explained in his lawsuit that during this incident, they were filming a scene where everyone was wearing onesies, but Blake had a big coat over hers. Justin, as the director, asked her to remove the coat so her costume would match the scene. He said, "It will be hot." But according to the lawsuit, he was referring to the lack of air conditioning in the small bar where they were filming, not her body. He also told her, "It's sexy," which according to the suit was meant to reference the costume choice, not Blake personally. When Blake appeared uncomfortable, Justin said he apologized more than once. So basically, Justin isn't saying he didn't use the word sexy while on set. He's just saying Blake took it the wrong way. This is one of those scenarios where context is everything.
Oh, it so is.
It really is, because in these situations, it's very difficult to know what the intention is. Now, based on a lot of the things that I have read and that I'm hearing, it feels like he was making her considerably uncomfortable during the process of the production of this film. It's pretty clear that he, let's say, violated the boundaries of what she felt was comfortable or safe. However, at the same point, you read this on paper, you don't know from the context what his intentions are. You don't know how she received it. Both parties are admitting these are the words that were said. It's sexy. It's hard to misconstrue that, okay? There's something about that when you can say, well, it's sexy, meaning it would be sexy for the scene. He didn't say you're sexy, did he? He said it's sexy. However, I still go back to the fact that if Blake was uncomfortable in this environment, this was all stuff that she was basically stockpiling in her head that just considerably pushed her to the boundaries of discomfort with him in this situation.
Well, especially when you take into consideration what we discussed last episode, which was that he rewrote the script without giving her a heads up or getting her input into it, and apparently rewrote the script to add in some much more sexually explicit scenes, which she became uncomfortable with. I could see how she could take it differently. And then you look at it, what would a reasonable person do in that situation? Would they take it the same way that Blake took it? Possibly. I also want to point out that this is what lawyers do, and lawyers do well, is they look at statements and figure out how something can be interpreted in any reasonable way to make your argument work. I'm not saying what they're saying is not what Justin intended. I'm not saying that. But it is very easy to look at something after the fact and tell your client, well, this is what you meant, right? Which fits whatever narrative they need. And then the client was like, oh yeah, that's exactly right. This may be, interestingly enough, the difference between how men communicate and how women communicate. We communicate so differently. Like, women use more words. It's well known. Women use more words when we communicate. Men use less words. If I had been saying I'm worried about the heat in where we're at, I would have said it will be hot in here if you keep it on.
Well, and again, this portion of this dialogue taken out of context. Number one, we don't know at this point. Number two,
we don't.
Is if I said you will be hot, how would you take that? Meaning that if I said, obviously you are hot, or it's going to be hot,
I'd be like, thank you very much, I am.
No, but that's all this matters, especially when you're getting into a court case.
Cases are determined on facts, and the smallest of a fact can completely change an outcome of a case.
Everything that I've seen up to this point, mostly about his vision for the film and how Blake is being put in consistently uncomfortable, erotic, playing his therapist when he breaks down to her in the trailer. There's a lot of things here.
That was just weird.
He's got some sort of like desired connection, or people can say, well, that's the artistic process, and it may very well be the case. However, it doesn't sound like Blake was on board for that at all. Again, he said, it will be hot. You are hot. It would be hot. Michelle, you're going to wear a coat in the scene. It will be hot. Meaning that to me, if I was saying it one way, it could be like, you're wearing a coat in the scene. It will be hot. Meaning with your coat on, it's going to be hot temperature wise for you.
Goes back to one of my law partners where he says, words matter.
They do.
And words matters. Because what he could have said was, it'll be hot if you keep it on. But I can assure you, if he had said something more like, it will be hot if you keep it on, that would have been mentioned in the lawsuit.
In all fairness, if you look at, is the scene meant to be erotic, sexy, hot, whatever terminology you want to use in terms of this particular scene wearing onesies? Is it a sexually charged scene, or is it something that he's putting his lens or POV on it because of his own interests or his own agenda?
There's a distinction to me between him saying it will be hot versus it's sexy.
Yeah.
It's sexy to me refers to not a person. That's how I would take it. The it will be hot to me is the more of the, that borders on, I don't think he was talking about AC. But here's the other problem is you had to be there because the tone in which he said it matters. His demeanor when he said it matters. Like, it's just not the words.
Well, from a director's POV, give an example. There's an actor that may be uncomfortable with doing a scene. Then there's an actor who feels insecure about doing a scene. There could be a very big difference between that, meaning a director is making an actor feel uncomfortable, or an actor doesn't feel that they want to wear something in a scene because they're uncomfortable or they're insecure about themselves. Why was she wearing a coat in this scene when she knew they were going to be wearing onesies? Was it a creative choice, or was it something that she felt uncomfortable being that revealing around him? Who knows?
Or maybe she runs cold?
Context is everything.
Context is so everything. There were other claims too, backed by what Justin and the other plaintiffs described as evidence. But the so-called evidence didn't always seem to support their version of events. For example, they argued that Blake refused to meet with the intimacy coordinator, forcing Justin to handle those conversations himself. But the only proof they've included was a screenshot of Justin texting Blake, "Just hired intimacy coordinator, will set you up to meet /FaceTime for intro." Blake replied, "I feel good. I can meet with her when we start. Thank you, though." In my opinion, that exchange doesn't necessarily suggest that she refused to meet the coordinator, just that she was fine waiting until filming began. I can assure you that if there was a statement from Blake where she said, "I'm not going to meet with her," that would have been used as evidence. But instead, they had that statement from her, which does not support that she refused to meet. Now, there may be outside verbal discussions that she and Justin had where she said that. Don't know, but that's not what's referenced. They just put up that text message, which to me doesn't support that claim. In another example, they claim that Blake's publicist, Leslie Sloan, told a Daily Mail reporter that Blake was accusing Justin of sexual assault, not harassment. But the screenshots they provided didn't mention sexual assault at all. So I'm not sure exactly what they are talking about here because, y'all, there is a distinction between sexual harassment and sexual assault. And that's not a little bit of a distinction. One will end you up in a penitentiary, one may not.
The suit also insisted Justin had been consistent from day one about wanting the film to focus on domestic violence and raise awareness. It denied that he had ever gone rogue during the promotional campaign. But their own proof of that was a screenshot of Justin texting on August 11th after the movie premiered. "I want to be the one that always directs it back to the survivors," and suggesting the team create a carousel of messages from survivors. I could go on, as the lawsuit is full of examples like this, but I think most of you listening already know how this ended. And if you don't, spoiler alert, Justin's lawsuit was eventually thrown out. And based on what's in the filing, are you surprised by this, Michelle?
Surprised it was thrown out? No, not necessarily. There are lots of preliminary motions that can be filed in cases to get them dismissed from the jump. And this is what looks like what Blake's team did. So does it surprise me? No. But spoiler alert, doesn't prevent him from refiling. Before we move on, I want to share Blake's attorney's response to this lawsuit. They called it another chapter in the abuser playbook. This is an age-old story, they said. A woman speaks up with concrete evidence of sexual harassment and retaliation, and the abuser attempts to turn their tables on the victim. That's what experts call DARVO, deny, attack, reverse victim offender. I've encountered what we call victim shaming a lot in my career, and Jake, I know you've seen it, is the victims, they need to be male or female victims, get personally attacked in hopes of discrediting their claims. And with women in particular, because this is actually what's played out in some of the media, it is, have you listened to the part where she's at home wrecking whatever because all of the men she dated were married at the time she started dating them or were like talking to them? There's been some coverage in the media about that with regards to Blake. And that drives me absolutely nuts because they bring it back to, well, but she's really not worthy of making this claim because of these issues. And that infuriates me because when you have a powerful, successful woman, what do? You slut shame them because you can't attack them for their intelligence. You can't attack them for their career. You can't attack them for what they do, but you can attack them on areas they really can't defend themselves. Because if it was a guy, the conversation's different. There is no slut shaming. We all bleed red. I'm all about we all have worth. We all have value. Doesn't matter your station in life. It doesn't matter what you do for a living. We are all human beings. If anyone's going to come in here and say that there are not differences between how men and women are treated, is simply fooling themselves, number one, and two, living in an alternate reality. Because there is a distinction. Like, I can go in a courtroom and I can't behave the same way my male counterparts do. Just can't. And I know that. So I work with what I have and my skill set as a woman, and I embrace my femininity when I go into a courtroom because I can't attack like a man can. I cannot. And I can't be indignant and jump up and down because they're he's zealously representing his client and man, she's a bitch. And that's just the reality. And I hate to say that that's the reality, but that's the reality. And so it goes back to my whole philosophy is sometimes to change the system, you have to get into the system first before you can break down all the walls, before you can kick that door down. And that's what you have to do. You got to work the system. And sometimes working that system relates to gender roles. And it sucks that we have to do it. But welcome to the real world. Just days later, Justin released roughly 10 minutes of the behind-the-scenes footage from the set, an attempt to refute Blake's claims of harassment. Yeah, I wonder how long it took them to come up with those selected 10 minutes of behind the scenes. The clip focused on the slow dance scene between their characters, one of the moments Blake had pointed to as uncomfortable and unscripted. Justin added a caption over the footage that read, "Both actors are clearly behaving well within the scope of the scene and with mutual respect and professionalism." Blake and her team dismissed this release as a stunt. They said every frame of the released footage corroborates to the letter what Miss Lively described in her complaint. So, again, this comes down to context matters. So they issued 10 minutes of behind-the-scenes footage from the set. They don't tell you what happened before. They don't tell you what happened afterwards. They don't tell you what was said before, what was said afterwards, because context matters. It's kind of like when we have recordings in court, and it's he who records loses sometimes, because the person that's recording or the person that's producing the recording controls the content. And so you don't know what was said before that could have entirely changed how that 10-minute scene is interpreted.
Before the February 3rd hearing wrapped, the judge issued a warning to both sides. He reminded them if the case continued to be litigated in the press, he had the authority to move up the trial date, calling it a last resort if public commentary made it impossible to seat an impartial jury. He said he didn't want to do that, but he would if he had to. The judge also made it clear neither side was to say anything in the press that could influence a potential jury. Michele, what does the judge's response tell you?
Exactly what I talked about before. Y'all, there's a gag order. No one's talking to the press anymore because it's exactly what I said. They were trying to influence a potential jury panel. And if you were living in one of the cities in which a jury trial would have taken place, so in either New York or California, I'd be willing to bet there was more discussions with the press in those particular areas. I couldn't tell you that if that's a fact, but I wouldn't be surprised. And that's the judge basically telling them to stop, to be professionals, and litigate it in the proper forum, which is the courtroom.
I have an issue personally with courts' inability to pick an impartial jury, considering the major saturation of anywhere anybody can get internet. They can be influenced based on this case. We're not in the era where local newspapers or television will cover things in one marketplace. We're in a global information age. So how difficult is it for the courts to mandate this?
The court can't stop media entities from reporting their own, but a court can stop attorneys leaking information to the press. And I think that's the distinction because, at least in the States, we've got First Amendment freedom of speech. The press can do what the press needs to do. But it does stop the leaking of information from the actual litigation teams. And I think that's where the difference is.
The judge is only concerned about what information is being leaked or shared or combated in the press by either party, not necessarily a news outlet or an influencer's ability to cover that case.
So what I will tell you is this. A court has no authority over anyone that is not a party to the litigation in front of the court. And so unless the Wall Street Journal was a party to that litigation, the judge cannot issue any orders to the Wall Street Journal. Just can't. The court can issue injunctions to the parties in litigation and their agents. And that's what this judge did. The judge basically said, knock it off. We're going to try this in a courtroom. We're going to try it in front of a jury. Stop trying to play us out in the media. Knock it off.
Let's say one of these media personalities has an ownership stake in a major periodical. Let's say like the New York Times. I'm going to go further. Jeff Bezos is being sued. He has a stake in the Washington Post. The Washington Post has reported favorable stories about him, but not favorable about someone who he's now in court with. Can the Washington Post be drugged into the same conditions that you said based on what the judge can do for either party like this?
It depends on the laws of the state where the litigation is, because that may dictate what can happen. But generally speaking, I think that organization would have to be added as a party to the litigation. By mid-February, Blake filed an amended version of her lawsuit. In it, she alleged she wasn't the only woman who raised concerns about sexual harassment on the set of It Ends With Us. She also added a new defamation claim based on what her attorneys called the repeated false statements the defendants have made about Blake since she filed her original complaint. Justin's attorneys responded with a statement of his own, dismissing the new filing as filled with unsubstantial hearsay of unnamed persons who are clearly no longer willing to come forward or publicly support her claims. He added, since documents do not lie, and people do, the upcoming depositions of those who initially supported Blake's false claims and those who are witnesses to her own behavior will be enlightening. What is truly remarkable here is Blake's lack of actual evidence. In March, Blake and Ryan filed motions to dismiss Justin's complaint entirely. Blake's attorney cited California Civil Code Section 47.1, a law that protects people who speak out about harassment or discrimination from being sued unless it can be proven they acted with malice. And what the nuts and bolts of that means is you have to prove that they basically willingly, intentionally, and knowingly are making false statements about you with the intention to harm you. That's a really high bar that clearly the judge didn't think that Justin's lawsuit met. In May, Justin's legal team issued a subpoena to Taylor Swift, hoping to figure out what all she knew about the case. Blake's attorneys were not happy about this. They responded publicly the same day, saying Justin and his team continued to turn a case of sexual harassment and retaliation into entertainment for the tabloids. This is a very serious legal matter, not Barnum and Bailey's circus. Less than a week later, Justin's attorney sent a letter to the judge accusing Blake of threatening to shame Taylor unless she offered public support. Blake's team called the allegation completely false, and the judge dismissed the claim.
Next, Justin's attorneys asked the court to compel Blake to identify her medical and mental health providers and sign HIPAA releases for access to her therapy notes. In response, Blake withdrew 2 of her emotional distress claims about prejudice, meaning she could refile them later. The judge approved the request, and this blew up in the media. A lot of people thought it meant that Blake was admitting she hadn't suffered emotional distress.
That's not what that means at all. That's not what that means. What that means is that her claims for emotional distress that she made, that she dismissed or took out of her complaint when she amended her complaint, that means those particular claims gave the right for Justin's team to ask for those mental health records. And by removing those claims, they were no longer entitled to them. That was an absolute ploy so that they can't get access to those records of hers. And when they reserve the right to amend it, which everyone has the right to amend up until so many prescribed days before trial, that's just how the legal system works. You can always amend your complaint to add more causes of action or add additional grounds for recovery. So she's allowed to do that. But without her making those claims, they don't get access to those records of her mental health. That was absolutely strategic on her team. They said, nope, we're going to remove those from our pleadings, Judge. We reserve the right to add them later, which they have the right to do anyways. In addition to that, it prevented them from getting access to those mental health records. Her attorneys explained to People, "This is a routine part of the litigation process that's being used as a press stunt. We are doing what trial lawyers do, preparing our case for trial by streamlining and focusing it. They are doing what they do, desperately seeking another tired round of tabloid coverage." They emphasize that Blake continues to allege emotional distress as part of numerous other claims, including sexual harassment and retaliation. Justin's attorneys pushed back against Blake's decision to drop some of her claims. They accused her of trying to avoid turning over documents while preserving the right to bring the claims again in the future. Ms. Lively cannot have it both ways, they argued in a letter to the court. The judge clarified in a ruling that if those specific claims weren't dismissed, Blake would not be allowed to present evidence tied to them. However, she could still offer evidence of emotional distress relating to her remaining claims. So basically, here's what it boiled down to. It was, if you don't want to produce your mental health records that are help you support your claims for emotional distress, and if you don't dismiss them, I'm not going to let you talk about them in trial because they're not going to be able to get the mental health records to show whether your claims of emotional distress are accurate or not. And so you're not going to get to do them anyways. And so her attorney said, fine, we'll dismiss. And so for Justin's attorneys to say that they accused her of trying to avoid turning over documents while preserving the right to bring the claims in the future, she's entitled to do that. Any litigant is entitled to do that. That is not something new. But if I was Blake's team, I would have done the exact same thing because based on how much is getting done in the press or in the media, I wouldn't want to turn over my mental health records to them. And I'd want a confidentiality order. If they are, which I can assure you, if that becomes an issue and she adds in those claims again, I can about assure you there will be a hearing on those records being sealed and those records not being produced to anyone outside the experts or the attorneys in this case. The court could probably go so far as limiting Justin's access to the records and say, nope, the attorneys get the records, they get the access to it, but your client cannot see it.
On June 9th, Blake's team got the ruling they were hoping for when the judge dismissed Justin's $400 million lawsuit against Blake, Ryan, their publicist Leslie Sloan, and his separate defamation suit against the New York Times. In his opinion, the judge wrote that Justin's claims didn't meet the legal standard for civil extortion. He said the Wayfarer parties failed to show that Blake's actions were anything more than legally permissible hard bargaining or renegotiation of working conditions. He also noted they hadn't shown that her alleged threats caused them actual harm.
When it came to defamation, the judge was equally clear. He wrote, the Wayfarer parties have not alleged that Blake is responsible for any statements other than statements in her complaint, which are privileged. In other words, because Blake's allegations were part of a formal legal complaint, which I discussed a little bit ago, they can't be used as the basis for a defamation suit. And that, to me, seems completely logical. The judge also rejected the idea that Ryan, Sloan, and the New York Times had defamed anyone, writing that the Wayfarer parties failed to show that any of them had reason to doubt the truth of what they said. In his opinion, the judge further addressed the New York Times article. He acknowledged it may have been dramatized, but said it was clear the paper had reviewed the available evidence and had no obvious motive to favor Blake's version of events.
In the end, most of the claims in Justin's lawsuit were dismissed with prejudice, meaning they cannot be refiled. The only exception was a narrow portion involving Blake's alleged interference with promotional deals. Justin was given until June 23rd to amend that part of the complaint.
Blake's legal team called the dismissal a total victory and complete vindication for Blake, along with those that Justin and the Wayfarer parties dragged into the retaliatory lawsuit. They went on. As we have said from day one, this $400 million lawsuit was a sham, and the court saw right through it. The New York Times issued its own statement calling the suit a meritless attempt to stifle honest reporting. The paper said it was grateful to the court and reaffirmed its commitment to protecting its journalists and their work. Justin's legal team pushed back, saying Blake's declaration of victory is false. They plan to march forward with their case, introducing additional evidence and refined allegations. Although Justin's lawsuit was dismissed, Blake's lawsuit against him was still moving forward. On June 12th, Justin's attorneys again subpoenaed Taylor Swift's text messages with Blake, even though they'd given up on that in the past. In response, Blake's team filed a motion for a protective order, asking the court to block access to those communications. They argued good cause exists for this request because it has been the Wayfarer party's tactic since August of 2024 to make Ms. Swift and her fan base central to their media strategy against Miss Lively. But the judge denied the request. In his ruling, he wrote, given that Blake has represented that Swift had knowledge of complaints or discussions about the working environment on the film, among other issues, the requests for messages with Swift regarding the film and this action are reasonably tailored to discover information that would prove or disprove Blake's harassment and retaliation claims. I got to tell you, it's fair game. It's fair game. If Blake said that she had communications with Taylor about this litigation, and Taylor was a person of knowledge of relevant facts, subject to being subpoenaed. Now, what's interesting is what the court said was that the requests are reasonably tailored to discover information. That's actually a legal standard of what information is subject to discovery, which means subject to the other side requesting it and you having to produce it. What I don't know, which I also would like to know, is those text messages between Taylor and Blake are going to be redacted to some extent, because what they have to turn over, and this is the important part, is they have to turn over messages that relate to the claims of harassment and retaliation. And so any text messages that they have that do not relate to that are going to be redacted. So what I can see happening is a fight over the redactions and Justin's attorneys wanting unredacted text messages between them. And then there's going to be a whole argument about that, would be what I suspect is coming down the pipe.
Well, I think this also puts people in a position where they start to reframe when you communicate with someone outside of a direct conflict, because this is a very interesting thing. I mean, you've got arguably the most powerful and popular pop star in the world, right?
Right.
And her privacy is now technically being invaded based on communication with her friend, who they also happen to be involved in this business venture together, the movie. It's not like Taylor Swift was just someone that Blake was leaning on to kind of talk about conflict in her life, but Taylor's actually involved in the film using her music. I do feel like there's a lot of shaming going on here, knowing they may not win a case, but they may be able to cause reputational harm or damage based on the public perception of their actions behind the scenes.
What's frustrating to me on multiple levels is the fact that I call them keyboard warriors who sit behind a keyboard, have nothing else to do, and go out of their way to destroy someone's life. And these are real people with real families, with kids, with wives or husbands. And when you go after people like that without knowing all the facts, without doing the critical thinking behind what's going on, I mean, you're just as bad as someone that's perpetuating a story that's not true. And the other part is, I've got a good friend that gives me lots of lines to use. And one of his lines is, there's 3 versions. There's a version of either side, and then the truth is somewhere in the middle, and that's version 3. Because everyone views what's happened to them in life through their own lens, through their own perspective. And so there may be some of Blake maybe being oversensitive to some of the things, but there may not be. She may be perfectly reasonable in her discomfort. And from Justin's perspective, because through his lens, he may think he did nothing wrong. I mean, he may legitimately think he did nothing wrong. And if you add in an additional layer of personality disorders, and I'm not saying that anyone has a personality disorder involved in this case, please understand that. But when you add in some other complexities or some other mental health issues that may or may not exist, it can also affect how you view things. Like someone that's got narcissistic personality disorder, and I know everyone uses the term narcissist and it's so overused because you can have narcissistic traits without having narcissistic personality disorder. Let's be real clear. But anyone in Hollywood is going to have some narcissistic traits as a general rule, because you as an artist, as an actor, as a producer, as a director, have to have some sense of, I'm a badass thought process and I'm awesome. Go do it. That is a narcissistic trait. Doesn't mean you're a narcissist, just means you have the trait. And some of those traits make you people very successful in life. I can about assure you, every CEO has some traits of narcissism. It's not a bad thing. But when you add in some of those other things, it changes how, or some of those other personality traits, it changes how you perceive things. And so that's why when parties say, this is my version, the truth is probably somewhere in between.
Blake's attorneys responded in a statement. Justin's desire to drag Taylor Swift into this has been constant, dating back to August 2024 when the crisis PR firm led by Melissa Nathan included her in their scenario planning document, referred to her as a bully, and called for a strategy to influence the TS fan base. They added, "We will continue to call out Justin's relentless efforts to exploit Ms. Swift's popularity, which from day one has been nothing more than a distraction from the serious sexual harassment and retaliation accusations he and the Wayfarer parties are facing."
Then, on June 23rd, the deadline for Justin to amend his lawsuit came and went without refiling. Instead, his attorney released a statement saying, "Instead of revising the existing claims, our clients will be pursuing additional legal options that are available to us." He added, "The court's decision on the motion to dismiss has no effect whatsoever on the truth that there was no harassment nor any smear campaign, and it does not in any way affect our vigorous defense against Blake's claims. Discovery is proceeding, and we are confident that we will prevail against these factually baseless accusations." Blake's spokesperson fired back. The court dismissed the frivolous $400 million Justin Wayfarer lawsuit in its entirety, they said. In the days that followed, Justin's lawyers said the judge's decision to dismiss their case was not a big deal as they promised to amend and refile it. As per usual, that was not true. The court's dismissal of Justin's sham lawsuit was a total victory after all. I got to tell you, if you are saying, I'm going to refile, because the judge may have given them a chance to refile, to correct the errors in their pleadings, and if you don't, that is an indication that you don't have it. As of now, Justin and Blake are expected to go to trial in March 2026. And there will likely be plenty of updates before then. Updates are coming out on this at least weekly. So while I can't guarantee, a trial date is likely to get changed. Here's what I will predict will happen in the next few months. And really, it's just going to be a ratcheting up of the litigation. Things will quiet down a little bit because the discovery process between the attorneys will be lots and lots of paper shuffling. But what will be interesting is the amount of depositions that get noticed. How many depositions are held. That's where it's going to be interesting. It's going to be interesting to see what Taylor Swift's attorneys do, because I can assure you Taylor Swift is not going to any deposition without a plethora of attorneys surrounding her. Because what's going to happen is someone will leak to the press if it's not in the public court record. You don't necessarily have to file. And again, it depends on the state. Sometimes you don't have to file deposition notices with the court. And so the public wouldn't know if a deposition was going on or not. I think it's a little bit different when you've got third-party witnesses. And what I mean by third-party witnesses is a person that is not a party to the litigation. Those depositions get handled a little bit differently with notification requirements. That part's going to be interesting because depositions, for people that don't know, that is the same as testifying in an open court. Everyone thinks, it's a conversation. It's not really a big deal. No. That is your testimony under oath, and it can and will be used against you. I wouldn't be surprised, honestly, to see Justin Baldoni file another lawsuit in his team. I think they're going back and re-strategizing what they're doing and how they're going to approach it. So I strongly suspect there's going to be either counterclaim or some other lawsuit file, but most likely some counterclaims. This is interesting because it's not one that I can do a final thought on because we don't know where this is going yet. I know that by the time even this hits the air, there'll have been additional developments. And so what I plan on doing is coming back with another update on this case because this is far from over. It's far from getting more salacious. It is far from not being tried in the public sphere. And I think there'll be a lot more updates that probably need to be explained so that the regular people that listen can understand what litigation actually means and what's actually going on. Lawyers have a really bad habit of talking in acronyms and big words that most people don't use in their everyday speech. And once you break it down to the nuts and bolts, it becomes much easier to understand. And then You can actually see what's going on as opposed to just hearing the inflammatory or bolstering statements issued by attorneys. So, stay tuned. Thank you for joining me on today's episode. I'll be back with a brand new episode. And remember, there are lots of four-letter words in family law, and fair isn't one of them. Until then, I'm Michele Locke, and this is Love Lust Law. Love Lust Law is hosted by me, Michele Locke. Jake Deptula is executive producer. Haley Gray is producer, writer, and researcher. Jared Landis is sound editor and mixer. Want to reach out to me? You sure can. You can email me at hello@michelelocke.com. Want to find out what I'm up to? Well, you can on Instagram and follow me at attorney Michele Locke. Just remember, Michelle is spelled with one L, and you can thank my mom, Margot, for that.